so as to preserve, and I emphasize, so as to preserve the hope of the citizens in our justice system. So that, my lady, even as the society submits before you, it behooves the court, by dint of also this section, to make decisions that will preserve the hope of the citizens in our justice system. My lady, reference has been made to section 123A of the CPC, which asks the court to consider the nature and seriousness of the offense while considering the application for bail. And from a cursory look of the amended information, my lady, the statement of offense is murder, a capital offense. My lady, I refer the court to the case of Republic versus Danson Gunya and another, where the court held and found that for instance, an accused person charged with capital offense is likely to flee from the jurisdiction of the court than one charged with a misdemeanor, like a frame. My lady, the distinction between capital or non-capital offense is one way crystallized from the realization that the atrocity of the offenses is directly proportional to the probability of the accused person absconding. So that, my lady, part of the reasons that the court would consider denying bail is the likelihood of the accused person attending court trial. My lady, I'll make reference to paragraph 30 and 31, which has cited the fourth accused as a deserter by the NPS, and would like the court to take judicial notice of an ongoing case, that is the Baby Pendo case, criminal case number E074/2022, where one of the suspects then was a police officer of superior command, one Mr. Mohammed Ba, has to date been a fugitive, has escaped from the jurisdiction of this court, and has defeated justice by not submitting himself to the court process. So that I seek the court to consider the grounds given at paragraph 46, which include risk of flight, risk of interference with witnesses and evidence, threat to public order and safety, and undermining the integrity of the trial. My lady, I associate myself with submission by Mr. Kisukwa and do confirm before this honorable court that I was instructed to represent one Kevin Mwinde, who was also arrested under similar circumstances with similar allegations, and I confirm to this honorable court that the said Kevin is fearful for his life. He has since recorded his statement with the investigating agencies, IPOA, and hence a potential witness in this case. So that, my lady, considering section 49 of the bail and bond policy guidelines, my lady, the court is enjoined to consider the safety of witnesses and or victims. My lady, I'll finally submit and make reference to a case that my good friend and senior, Mr. Bale, submitted on. This is Republic. Sorry, Mr. Obeta.
I missed the job.
Bond was submitting on behalf
What's
of
here
Bale.
only what is relevant. They are blind and deaf with those words. Proceed, Mr. In
Mr. Mango,
Republic.
yes, Republic versus Frederick Oleleliman
Yes.
and 4 others. My lady, this matter was considered by her Lady Justice Lesit, as she was then sitting at the High Court. And my lady, I'd like you to consider paragraph 72, where the court considered public interest. And the court noted that in regard to public interest, the compromise of the criminal justice system through various forms of interferences with the case, all the law requires is that there is interference in the sense of compromising or inducing or terrifying or doing such other acts to a witness with the aim that the witness will not give evidence or will give particular evidence in a particular manner. My lady, the court considers that interference with witness covers a wide range, my lady. My lady, it can be immediate on commission of the offense, which we've had through interference of the CCTV. My lady, during investigations, and at the inception of the criminal charge in court, or during trial. So, my lady, those instances have already been unveiled before you. But, my lady, the issue of interference of witnesses, the court found it not to be a fertile imagination, as had been submitted by Mr. Obeta, and made reference, and I refer the court to paragraph 75. The court noted